So thank you, Sebastian. So thank you again for joining us at the Berkman Klein Center for Internet and Society for the Double Black Box, National Security, Artificial Intelligence, and the Struggle for Democratic Accountability. This event is generously supported by Orrick, Harrington, and Sutcliffe LLP through the Orrick Colloquium on Cybersecurity and Cyber Law at Harvard Law School. So Professor Deeks' book is available for sale. You may have seen it outside. It's available today just with cash, but you can also just share your information if you just have card or tap and provide it at the Coop anytime this week. And so today you can still walk away with a signed book. So just to be aware of that. And let me introduce our moderator today. Kristen Eichenseer is a professor of law at Harvard Law School whose research explores the intersections of foreign relations, national security, cybersecurity, and international law. She's a member of the U.S. Department's Advisory Committee on International Law and an advisor for the Restaurant Fourth of the Foreign Relations Law of the United States. Before entering academia, she clerked for Justices Sandra Day O'Connor and Sona Sotomayor of the U.S. Supreme Court and for then Judge Merrick Garland of the D.C. Circuit. She also served as special assistant to the legal advisor at the U.S. Department of State. So thank you very much. There you are. Thank you very much. And before I turn things over to our speakers, there's a special tool that we'll be using today in our event. So Sebastian, if you can just go to our next slide. So this is a tool created by BKC to kind of optimize your takeaway from our events. It's basically a way to stay more engaged, and it's a bot. So you can, by using brk.mn/eventbot, you can ask the bot questions about the event. So I just zoned out. What did I miss? Or she just mentioned the name of an organization. What's that called? So feel free to engage with it throughout the event. We tried it out last week to great success, I would say. And we're also looking for feedback right now. So at the end of the event, we would love to hear from you at brk.mn/feedback. Just to flag, this tool uses the OpenAI 4.0 mini model through the Harvard API proxy. And the message log is just visible to our engineers. So with that, thank you so much, and we hope you enjoy the event.
Thank you very much, and thank you to Berkman for hosting, and thank you to all of you for being here. I'm absolutely delighted to welcome Ashley Deeks. Professor Deeks is an expert on national security law, and she also serves as the Vice Dean at the University of Virginia School of Law. Both before and after becoming an academic, Professor Deeks held high-level positions in the U.S. government. She served most recently as the Deputy Legal Advisor to the National Security Council and as Associate White House Counsel from 2021 to 2022. Before becoming a professor, she served as the Assistant Legal Advisor for Political Military Affairs at the U.S. Department of State. And she worked there on issues related to the law of armed conflict, the use of force, the legal framework for the conflict with al-Qaeda. And she also advised on intelligence issues and served as the Embassy Legal Advisor at the U.S. Embassy in Baghdad, Iraq, during Iraq's constitutional negotiations. Professor Deeks jumped to academia in 2010 when she became an academic fellow at Columbia Law School and before joining the UVA faculty in 2012. Since that time, she's written articles on the use of force, executive power, sanctions, secret treaties, the intersection of national security law and international law, the laws of armed conflict, and the legal aspects of the US-China tech competition. She's a contributing editor to Lawfare, as well as a member of the State Department's Advisory Committee on International Law and the American Law Institute. Professor Deeks is a graduate of the University of Chicago School of Law. She was elected there to the Order of the Coif, served on the Law Review, and after graduation clerked for Judge Becker on the Third Circuit. She's here today to talk about her first solo authored book, which you all see outside, The Double Black Box, National Security, Artificial Intelligence, and the Struggle for Democratic Accountability. The book is a blueprint for hugely important issues that will define the intersection of government, national security, and artificial intelligence for years to come. There's always a risk with law and technology books that they will be overtaken by events or become quickly outdated. That's not going to happen with this one. This book is asking the most deep and fundamental questions about the relationship of national security and artificial intelligence, and it answers those questions in ways that are going to be relevant for policy for years to come. Professor Deeks is also, I think, uniquely situated to write this book. This book could only have been written by someone who had served in the government and been inside the national security black box at the advent of the AI revolution, as well as someone who couples that experience with serious, creative, and thoughtful scholarship and exceptionally good judgment. So now that I have thoroughly embarrassed her, I would just say we are thankful that you made the trip up to be with us here today. So let me start off with just a question and ask you to explain, what is the double black box?
Sure. Well, thank you so much for that overly kind introduction. And thank you to Berkman Klein for hosting. I'm excited to be here with all of you today. So the title of the book obviously invokes this idea of a double black box. And what I mean by that is, is she adjusting the? Okay. So the first black box that I write about is the national security black box. As many of you know, the US government and frankly a bunch of other democratic governments have to do certain activities in secret. They have secret technologies, they are engaged in secret activities, and for those activities to be successful, they need to keep them secret from our adversaries. What that also means, of course, though, is that they have to keep them secret from us, the public. And so you will sometimes hear national security referred to as a black box because so much of this activity necessarily takes place behind the veil of secrecy. We have some checks, we have some actors who can look behind that veil of secrecy. We'll probably end up talking about some of those actors. These are certain committees in Congress, some narrow set of our federal courts, and maybe some other less traditional actors. But in general, we have a national security black box that we have long had to wrestle with. And it struck me when I first started thinking about this book that we have a second black box before us now, and that is the AI black box. These tools, these deep neural nets, sort of high-level machine learning tools are quite opaque in terms of how they are making the predictions that they are making. And they are opaque not just to the users, they are often opaque to the very people who are developing the tools themselves. So I started to be interested in trying to tease apart what's going to happen as the AI black box really finds its way into the national security black box, hence the double black box, and trying to think about the ways in which this move will ultimately potentially complicate even further our attempts to try to ascertain whether our government is acting lawfully and effectively when it's engaged in these secret operations.
Great. So can you talk a little bit about the extent to which your concerns about the double black box are sort of a present problem versus a future problem? So maybe is there an example of an instance where you see the double black box issue kind of coming up today with present capabilities, and maybe then forecast for us, like what's a future example that the government doesn't yet have a capability, but you see this coming?
Yeah, so good question. I'll just back up to say in 2018, when I started to write this book, I thought, I need to spend a little bit of time in the book explaining some sort of possible future uses of AI by the Department of Homeland Security, by our military, by our intelligence community, because I really feel like I will need to sell people on the idea that this is going to be a problem. And I will say today in 2025, I feel like I had to do less work to actually persuade people that this is coming, especially as we see things like the way in which Russia and Ukraine are using drones in their conflict right now. And they're maybe not fully autonomous drones, but they are getting pretty close. And that is not, I think, where the landscape was in 2017. I think we are seeing AI now thought of as something more like electricity. It is going to pervade every aspect of the national security state. I am persuaded it will implicate the way in which the intelligence community is collecting and analyzing and processing information and it will affect everything from logistics in the military to the development of new materials for weapons to the actual deployment of force. So I think we're moving to a place where it's really going to be everywhere. The fact that we don't know for sure is part of the bug of it being a double black box. I don't think we know exactly what each of these agencies is doing. Sometimes reports will pop out in the news due to things like leaks, but we're not 100% sure. But a couple of things that maybe just to give two examples. One is concerns about cyber escalation. Whether this is a today example or a future example, I'm not actually really sure. But I think it's the case that the US government is already using AI for offensive cyber operations. And one thing that scholars have written about and thought about is what happens when, say, a US offensive cyber tool confronts an adversary's AI cyber tool, defensive or offensive, and concerns about the way in which those unpredictable confrontations between AI cyber tools may get us off to up an escalation ladder that maybe neither side really intended. So I think that's one thing people are thinking about, including as that relates to vulnerabilities of nuclear command and control systems. Another example that I had occasion to talk to a colleague about last week, this idea that we're going to have autonomous weapons systems deployed into what she has called kill boxes. So boxes on areas on a battlefield that a country might decide do not contain, or they don't think contain, civilian objects or civilians, and deploying autonomous systems to engage in uses of force against anything that moves inside that kill box. I don't think those exist as such today, but you can imagine that that would actually be something coming down the pike. So just to go back to this idea that I think AI is a little bit like energy, I do think we're going to move to systems in the national security space where lots of different AI systems are going to be interacting with each other, right? So AI systems helping to produce intel analysis, helping to process ISR feeds, helping to engage in electronic weapons jamming, and potentially targeting. And all of those systems together, it's going to be particularly hard to identify the source of errors, for example, or who's accountable for their use.
Great, that's helpful. And it was a little bit of an unfair question because your point is the opacity of the double black box makes it hard to tell what's present and what's future. So thank you for teasing that apart for us. So one thing you note about the book, and one of the key themes that you tease out, is the idea that ensuring executive compliance with public law values will require diligence by a wide range of actors. And I want to unpack both the values and the actors. So let's start with the values. Can you say a little bit more about what are these values that you have in mind, and maybe just to add on to that, the extent to which you think those are sort of consensus values at this particular moment in time?
Yeah, great. So it's a great question, and it goes back a little bit to why do we worry about government secrecy? One reason I think we worry is we are concerned about whether our government is acting consistent with what I'm calling and others have called public law values. And so I focus on 4 in the book. One is the value of legality or lawfulness. One is about the efficiency or effectiveness of government, right? We want our government to be effective, not wasting resources, not going down dumb dead ends. We want our officials to be in a position where they need to justify the decisions that they've made, and justify those decisions to someone other than the person sitting next to them in the office. Some other actor, whether it's to Congress, whether it's to the courts, maybe it's to a different agency, so a justification point. And then also accountability, right? We want to know who made a particular decision so that we can hold them accountable, whether it's a good decision or a bad decision. We know how to kind of trace the source of that decision making. So those are the 4 public law values that I focus on. There are others in the literature, but those seemed the most salient. for this. And I picked those values in an effort to try to be focus on process, because I thought that would be more neutral in this day and age. We obviously have a very polarized society right now. We have, I think, reasonable people can disagree about the deployment or non-deployment substantively of different types of AI tools. But my hope was that identifying these public law values was something that we could all kind of get around, that we all think that the government should be adhering to these values. Whether that still stands, I don't know, but I do think that it is a safer place to work from than to try to write a book that is saying you should use X tool and not Y tool substantively. That it seemed like it would provide a more solid basis. Yeah, so did you have a follow-on point to that? Oh, I think I've answered both pieces.
I think you have.
Okay.
I have more questions for you.
I'm sure you do.
So now we talked about the values. Let's talk about the checks. And you talk in the
Okay.
book about both traditional checks and non-traditional checks.
Yeah.
But I think by traditional checks, you mean Congress and the courts. But can you say a little bit more about other things that you would consider to be traditional checks and how they would operate given the challenges of the double black box?
Sure. So when I was trying to think about the kind of second part of the book, and having identified the problem, what are some of the solutions going to be? The obvious move is to look at what our traditional checks do with regard to government secrecy. And as you suggest, the most obvious check is Congress. It's actors like the intelligence committees in the House and Senate, the armed services committees, the foreign affairs committees. Those actors have access to classified information. I think especially on the Intelligence Committee, all of the members are cleared for the sort of highest levels of what the executive's doing. And so they are one actor we should be thinking about in terms of what they could do. And there I do actually, I have a section that proposes particular specifics that I think Congress could do. So, for example, Congress has enacted historically a range of framework statutes to try to deal with historical problems that have arisen behind the veil of secrecy. So think Watergate, think spying on US citizens and engaging in a range of overseas assassinations. Congress came in, it enacted a statute, for example, that regulates the use of covert action, regulates the use of foreign intelligence surveillance. I think Congress could, if it had the political will, enact a framework statute that would regulate the highest risk uses of AI. So AI that might implicate life or liberty, for example, and require the president to sign off on those particular uses of this high risk AI, presumably in consultation with a range of agencies that would have views on the legality of that kind of activity. Congress has done a little bit of work to date in this space. There have been a number of bills proposed that have been kind of interesting. For example, Congress has said, we know the Department of Defense has a directive that requires a certain type of review for autonomous weapons. We, Congress, would like to know when that process has been used, whether it has authorized the use of a particular autonomous system, and what the effect has been when the system has been deployed. So that's, for example, one thing that, that Congress might be able to do. I should say there are a couple of problems with relying exclusively on Congress. So first is a structural problem. Congress has pretty limited resources compared to the very voluminous national security state. Many more executive branch actors in this space to oversee than there are members of Congress and staff. There are educational hurdles. For people who've been following Congress and what they've been trying to do in the tech space, Congress has not been able to regulate tech very effectively. There hasn't been the political will, and to some extent, there may not be the technological sophistication to do so. So that's going to be a challenge for Congress. Politics, of course, always a challenge here. And I think timeliness is another important issue. So we think about Congress as providing good oversight when it comes to armed conflict, partly because they can, in theory, weigh in the beginning. They can weigh in all throughout. I think the speed of AI is going to mean that it is going to be very hard for Congress to weigh in a timely way after the tools have started to be used. On courts, as many of you know, courts tend not to play a very significant role in overseeing executive branch actions in the national security space. And when they do step in because somebody has brought a case, they may decide that that person doesn't have standing, or they may decide that it is a political question, or they may decide that the executive is owed a lot of deference. So I don't think we're going to be able to rely heavily on the courts to do a lot of checking. But there are two potential ways in which I think courts might end up doing something. One is that the Foreign Intelligence Surveillance Court is a court that reviews government applications to engage in electronic surveillance. Very sensitive, right? Does this in a classified setting. And they have to review the idea that the executive branch thinks that the target is either a foreign power or an agent of a foreign power, and that the government has shown probable cause for that. It could be that the executive starts to use AI tools to develop that case, to develop the probable cause. And I can imagine that the Foreign Intelligence Surveillance Court is going to say, okay, show me how you got there. Show me your work. Is the AI tool you're using explainable, and so on. So I could see the FISC pushing the executive a little bit in this one space. The other thing that I think could happen is that courts may start hearing cases, maybe they are torts cases, or maybe they're administrative law cases. And part of those cases involve the use of AI by the government, not in the national security space, but in a kind of civilian setting. And the courts may start to work through some of these issues about explainability and accountability that will ultimately inform what's happening behind the veil of secrecy, not directly, but indirectly. So those are, I think, what I would say about those, the kind of primary checks that we go to.
I take from the book, though, given that you talk about non-traditional checks, that you don't think the traditional checks are going to be perfect. So can you walk us through a little bit of the non-traditional checks? Who do you mean, and maybe how optimistic are you that those checks will be effective?
Sure. And I will say, I think my overall takeaway is that there is no one silver bullet here. There is not one secret solution that we should turn to and rely on. I think all of the types of checks that we'll talk about here have some role to play. They're all going to take little bites at the problem, but it is not something we can just snap our fingers and make go away easily. A couple of different non-traditional checks that I want to talk about. I will say the executive branch is maybe, and especially executive lawyers, maybe counterintuitively, are a potential check. I don't always know whether to think about them as a traditional check or a non-traditional check. And again, it seems a little counterintuitive because the actor we're worried about in the double black box is the executive writ large. But executive lawyers are, and sort of traditionally have been, a kind of office of goodness, where they come in, they're trained as lawyers, they have a particular commitment to the rule of law. And to the extent that they are able to be engaged in the analysis about whether to use a particular AI tool, how to use a particular AI tool, and to have interagency disagreements with each other about the legality of some of this, I think is very healthy. So to the extent that executive lawyers are given access to these kinds of debates, I think they can be helpful. But three other ones I want to mention. So one is allies. By that, foreign allies of the United States, for example. And again, these ideas can also apply to other systems, could apply to Japan as it's thinking through AI, or could apply to France. But for us, the United States relies on allies for a bunch of things, including intelligence, law enforcement cooperation, use of the foreign government's territory or airspace. So those other governments have carrots and sticks, right? They can withhold access from us if they are concerned that we are using tools that may not be lawful, or that they themselves are unable to ascertain are lawful, or that they think are maybe not moral or not efficient. There is actually an example in the news in the past day or two where you see the United Kingdom saying that it is not going to share intelligence with the United States because it is worried about the strikes on reported narco trafficking boats. So that's the kind of example that I mean, where an ally has something that the US government tends to want, that they can withhold. So that is a potential check to the extent they can see behind the veil of secrecy and have some knowledge of the kinds of AI tools that the executive is using. US states are another player here. We know, and Professor Eichenseer has written a little bit about this, I think, in the cyber setting, but there are roles for US states in counterterrorism, for example, where they work with the federal government on sensitive issues to try to detect terrorist actors, for example. States are actually doing stuff in the AI space as well. And so I do wonder whether they are going to be able to play some kind of checking role. For those of you tracking state AI laws, you might know that California enacted a statute sometime in the past year, SB 53, that is thinking about frontier AI models and thinking about national security risks, including the use of these models to create bioweapons, for example, or to create real-world harm that affects dozens of citizens. So states may have some work here too. The final actor that I want to talk about is tech companies. Tech companies do actually, think about it in the cyber setting. Actors like Microsoft have visibility into a huge amount of cyber traffic. And they have relationships with the US government where they might say, hey, we're seeing what looks like a persistent threat coming from country X, and here's how it's manifesting itself. And they have discussions with the US government about that. And the government might say, we're seeing that too. We think it's from a different actor. So there's a kind of give and take, again, behind the veil of secrecy from these companies. Tech companies are obviously playing a really big role in creating these AI tools, some of which the US government is buying. So we have seen cases in which tech company employees have expressed concern that their companies are engaged in certain contracts with the US government. Project Maven was a kind of early famous example of this. There are also corporate whistleblowers. And some states are strengthening their corporate whistleblowing laws on the idea that if tech company employees are seeing things that are giving them a lot of pause, there would be a mechanism, a whistleblower mechanism that they could use. So those are, I wouldn't argue that's a complete list, but those are some of the obvious potential non-traditional checks.
Great. So I have to ask you, obviously, we've seen a change in the executive branch. So the executive branch of today is not the executive branch we would have been talking about a year ago at this time. So can you talk a little bit about whether you see on AI policy, is this an area of major continuity between the Biden administration and the Trump administration, or major discontinuity? Kind of give us the lay of the land and where things stand and where they've shifted over the last year.
Sure, and it sounds like Berkman Klein is going to do an event on the AI action plan, so that session may produce even more answers on that. I think it's kind of a mixed bag in terms of continuity. The Biden administration produced a number of documents towards the end of its time in office. One of them was a document, an AI kind of framework that would have produced some guardrails for national security AI that I think contains some helpful ideas that track a little bit the kinds of things that I suggest in my book. The Trump administration revoked the Biden era documents and issued an executive order that's called Removing Barriers to American Leadership in AI. That directed cabinet members to review earlier actions and revise those that were inconsistent with President Trump's order. The Trump administration issued this AI action plan. There's a little bit of something for everyone in that plan. I think there were something like 80 different recommendations. I would say overall, one of the big pushes in the plan is a push for faster adoption of AI in sort of across the government. There was also move to do things like potentially limit federal funding to states that try to enforce burdensome AI regulations. But there were also things in the plan that seem interested in making sure that the AI that we are deploying is solid. One thing was having DARPA, the Defense Advanced Research Projects Agency, continue to study interpretability, sort of the explainability of AI, to study AI control systems, make sure that AI doesn't kind of jump the borders you've set up for it. Running hackathons to develop best tests of AI transparency and effectiveness. It sustained a Center for AI Standards and Innovation to try to test AI systems for national security risks. So I think it's still kind of an open question how all of those things will actually manifest themselves in the real world in the next months and years. But there's stuff to work from that I think is positive.
So both the Biden administration and now the second Trump administration have been very focused on China. And I was just curious for your thoughts on the extent to which that tech competition with China you think is driving a lot of the decision making about the deployment of AI, the development of AI. I was wondering if you could speak to that a bit.
I think the answer is definitely yes to that. I think going back to this idea of deference to the executive, I think one reason the executive is getting a kind of policy deference, I think, on this topic is because there is a view that's pretty widely shared, not universally shared, but quite widely shared, that that China is the pacing threat on AI, right? That we know that China thinks that whoever kind of develops general artificial intelligence first is going to kind of win the world. I think we have a similar view ourselves. And so one thing you hear people say is, well, by establishing guardrails on AI to make sure that it is not being used in a reckless way or an unlawful way, are we inadvertently handcuffing ourselves in that contest between the US and China? There are other states obviously engaged in AI development, everyone from the UK to Russia to Israel. There are lots of other states involved. But thinking about it from the China perspective, are we handcuffing ourselves, or other democratic countries handcuffing themselves here? And I guess I have two thoughts on that. So one is thinking about the parallels to the laws of armed conflict. So the laws of armed conflict, a big body of international law that states have widely adhered to. Think the Geneva Conventions, for example. And there is not a provision in the Geneva Conventions that says if the state you're fighting doesn't comply with the conventions, you can start not complying with them. In other words, we have bought into the laws of armed conflict with the idea that we are going to follow them regardless of what our adversaries do, because that's who we are. And we think that they actually make us more effective on the battlefield. We think they create guardrails for our forces and so on. I also think that there are some inherent advantages to making sure that we're developing, I'll just call it responsible AI that complies with our public law values. I think you end up with greater societal trust in the systems. You will get greater military trust in the systems if you're asking your militaries to use these tools. Hopefully the tools will be more effective. That's going to help you win future wars more effectively and efficiently. And it may end up with economic benefits where you're producing tools that other states or allies might be interested in buying. So I do think it's the case that China's command economy and the levels of government surveillance allow it to gather larger amounts of data than our government. There are domestic laws that require actors, whether companies or individuals, to share data with the government at its request related to AI. Those are all going to enhance China's rapid development of AI, but I don't know that that says then we shouldn't care about guardrails.
That's all really interesting. And I think it's partly interesting because in reading the book, I would say that you're actually quite pessimistic about international law's ability to shape the sort of the uses of AI and the rules for how to use AI. But I couldn't quite tell, are you pessimistic? Is that pessimism specific to AI issues, or is that like broader pessimism at this particular moment about international law? I'm saying this as an international lawyer. I know you are also an international lawyer. This is a question against interest, but
Yeah.
where's the pessimism coming from?
Yeah. So I guess I will say I'm a little bit pessimistic about three different things in this space. So one is pessimism about the state of the international legal system generally. The second is the state of the US views on the values of international law, on its virtues and whether it's helpful to us. And the third is about AI itself. So I break those into kind of three buckets, and a little bit pessimistic about all three. So in thinking about, so most of the book is about kind of domestic legal questions. But it, of course, the question then arises, well, is one way to shrink the size of the double black box to establish international legal rules that will take some uses of AI off the table, right? That we and Russia and China and the UK and the EU, France and Turkey and will just agree that there's some things we're not going to do with AI. And when you start reading about that, one thing you'll see is that there are a number of people out there who say, we should think about this like nuclear weapons. Nuclear weapons were an incredibly important national security tool. And yet, two very serious adversaries were able to come together, this is US and USSR, or US and Russia, come together and conclude treaties that restricted our use of sort of number of nuclear weapons, locations, and beyond weapons, other sort of important missile systems and so on. So if we could come to agreement on that, surely we should be able to come to agreement on AI tools that are potentially going to have really significant international security implications. But there are lots and lots of differences between nuclear weapons and AI. Nuclear weapons are a thing you can put your hands on. They are things you can count. They are things where there is not a lot of debate about what the definition of a nuclear weapon is. AI looks entirely different from that in a whole bunch of fronts. Plus, there's also the kind of dual use nature of AI, right? There are lots of civilian purposes as well as military purposes, not so with nuclear weapons. So it occurred to me that the better analogy was actually cyber, trying to think about, well, how has international law been able to regulate or hasn't been able to regulate hostile cyber operations? And it turns out that it has not been able to do very much in this space. There is some basic agreement among states that existing rules of international law apply to cyber operations. So the UN Charter applies to cyber operations. Geneva Conventions apply at a high level of generality, but a lot of disagreement about how you translate those tools into kind of cyber operations. States have come up with some kind of soft law norms that should guide cyber operations. I think we've seen that a little bit in the AI space as well, not binding international law, but again, relatively high level norms that we think around, I'd say, responsible use of AI. There may be more activity in smaller clusters of states, kind of not multilateral, but minilateral groups. So think NATO, for example. The US is able to have a more detailed, more classified conversation with its NATO allies about what AI should and shouldn't be used for in this space. And then there may be some Maybe there's room for some very narrow bilateral agreement to, for example, keep AI out of nuclear command and control. So very sort of small slices. Maybe we and China and Russia could agree on that. But the state of international law right now, in terms of the relationship between the major players, doesn't give me a huge amount of confidence here. So that's why I kind of fall back to the domestic law checks to help us get out of the double black box.
So I don't want to end my questions on a pessimistic note. So let me pivot to optimism for a second and ask you, obviously there's a lot to worry about in the greater deployment of AI within the national security black box. But are there use cases or potential use cases where you see AI actually as likely to improve decision making within the national security black box or improve the achievement of public law values? So then we'll open it up for questions, but give us the optimistic endpoint here.
Yeah, sure. So I guess I should also say I am not against the use of AI in the the nuclear space. Well, there I am. But in the national security space, I think there are definitely really important contributions that AI tools can make in this space. So one easy one to think about is helping with declassification. So agencies are already starting to try to use AI tools to accelerate declassification of documents from 10 years ago. The archives, the National Archives, for example, way backed up in terms of the declassifying at a speed that's required by statute. I think AI can be really helpful in accelerating that process, which would advance accountability, legality, justification, right? So that was maybe a good example. I think in terms of effectiveness, one thing that AI systems can do is they can take into account all of the information that we have when they're trying to make a recommendation about a decision. Much, much more information than a single person can keep in their head, or multiple people in a room can keep in their head. And that could very much redound to the benefit of our military and intelligence officials. I think AI can also help on material science, right? Can help discover new types of materials that are going to be really helpful to protect our armed forces, for example. And I think have already proven to be helpful in things like logistics. And logistics really matters. I mean, I think if you watch the Russian troops headed into Ukraine, you realized we have a sort of logistics management chain that foreign militaries just don't. And I think AI could help us with that.
Great. I want to spend our last few minutes here opening it up for questions in the room and also online. So if you have a question, we've got a mic going around.
Hi, I'm Moritz, a student from the Kennedy School. My question would be, many of the kind of checks and balances you described are either relying on norms or third parties, be it a foreign power or a company. Given that public commentators might call the current state of the U.S. In a state of democratic backsliding or rise of more authoritarian style of government, wouldn't it be fairer to assume that there's some need for a clear check that does not depend on the goodwill of the executive or the adherence to norms, but rather something that would persist through someone in the executive branch that is basically willing to push through these kind of softer barriers? And whether there is anything in place like this currently?
So I think your question is maybe asking, would it be beneficial for there to be statutes on the books that would endure across administrations that would be stronger than norms, but actually would be articulated legal requirements? I do favor activities by Congress in this space. I mentioned the framework statute. I think Congress could, for example, develop a joint committee on AI that would better enable Congress to enact AI smart statutes. But I think for some of the reasons I mentioned, we can't put all of our eggs in that basket. I mean, Congress could tomorrow, if it wanted, enact a statute that said, the president must make a finding before he deploys high-risk AI, right? They definitely could do that. And I do see the advantages of building things into statute that endure. As you know, though, if you're dealing with technology that changes very quickly, sometimes statutes can get outdated faster than you would like them to. Although my normative recommendations do include recommendations to the executive, they do also include recommendations to the other types of actors that we've talked about, the US states, for example. They're not complying with norms necessarily, right? They're trying to decide, what do we as a state feel is appropriate for use of AI that can implicate national security? So it's the state legislatures drawing on the public. But I'll just end with the point that at the end of the day, all of us as citizens who are interested in this issue and who care about this issue do have basically an opportunity and maybe an obligation to share our views with the people who represent us in Congress, or the people who represent us in the states, or who represent us in foreign allies, to say, these are the kinds of tools that we do support and don't support, don't want to see our government using.
Yeah, I think we've got a question from online.
Thank you. Are existing traditional forms of internal oversight, e.g. lawyers, inspector general offices, GAO, etc., capable of the level of technical investigation necessary to evaluate AI systems? If not, what kinds of reform or augmentations could enable them to be more effective?
That's a great question. So I really like that question, because I do think that this is a challenge for lawyers. I know not all of you are lawyers here, but I'm a lawyer. Professor Egan's here, obviously a lawyer. And I think lawyers have work to do here to make sure that we are smart enough on these tools, that we are positioned to ask hard questions of both the policymakers and, maybe more importantly, the computer scientists, the people who are sitting there helping to develop these systems, right? You're making lots of value judgments when you are developing algorithms and training them on this data. And the people who are making those decisions may not even appreciate that they're making decisions that can implicate the law. So I think lawyers have a really important role to play in trying to be the kind of translator and go-between between policymakers who say, get me a tool that can do X, and a computer scientist who says, okay, I can do that. The lawyer needs to be able to translate what the goals are and what the legal frameworks are between those two actors. So I think that I don't know that requires a statute to do. I think that just requires us to start thinking about our potential role inside government and outside government to be that kind of translator.
Great. Yeah, June. Oh, okay.
Thank you so much for the thank you so much for the lecture. I just had a question. So AI can be vulnerable to adversarial attacks on throughout the entire life cycle of development and deployment. So for the AI that's used in military operations, where do you think that this security lies? Like, where in the black box does it lie, and where does accountability for security come in?
So you're absolutely right that the AI is subject to being attacked, subject to being spoofed, to made to do things that the creator didn't intend for it to do. The way that the US military thinks about this is through the process of a weapons review, at least if we're talking about AI systems that are either going to end up in weapons or weapons systems. And there's a legal obligation for some states to do this if they're parties to a particular treaty called Additional Protocol 1. We're not a party to that, but we are actually leaders, I think, in doing these weapons reviews. So the idea being, you need to ensure, if you're building AI into a weapon system, that system is going to be able to distinguish, for example, between a military objective and a civilian objective. If you're building a system that is learning on its own, you're not going to be able to do one and done. right? You're not going to be able to say, oh, I've done this weapons review. I'm going to deploy it in the field. The soldiers who are using it, they can tweak it. It can learn. That's fine. I think that there is an understanding within the government now that there is going to have to be a kind of entire life cycle set of reviews, and it's going to be partly for JAG lawyers to decide we are using this system in a different way from the system that was approved. We need to kind of put it back through a review to make sure it can still be used consistent with the laws of armed conflict.
Thank you so much.
Can you hear me? Thank you so much for coming today. I had one question. So I think if the goal is to shrink the double black box, you can either go about that by shrinking the smaller box, right, by making the AI more interpretable, or maybe shrinking the bigger box by, eating away at perhaps executive deference or national security deference. And I was curious if the potential catastrophic risks that unconstrained AI usage by an executive, whether that's mass surveillance or flooding the information zone, if awareness of those risks could lead to either judiciary or Congress saying that, hey, maybe we shouldn't apply traditional deference given an AI context, and maybe there should be more checks on the executive in that sense. Thank you.
This is always a hard question about whether there's something that's going to happen that would alter the way in which the courts think about their role in this space, right? The reason that courts are deferential is they feel as though they don't have the knowledge, the sophistication, the full understanding of the implications of shutting something down, how that would affect U.S. partnerships and allies overseas. They say, like, the executive branch, they're the ones who understand how all of that works. So I am skeptical that we will see in the near term courts decide to change the levels of deference that they are giving to the executive branch in this space. But I do think, kind of going back to a point I made earlier, that we may see some judicial decisions in cases that do not generally warrant national security deference, right? Just sort of straight up torts cases or administrative law cases where the level of deference is more reduced, that will inform how the executive thinks more generally about the use of particular AI tools, whether that's a greater requirement to demand explainability in the systems that they're using, for example. So it's an open question. We'll see, for example, what happens in the tariffs case. Will that tell us anything about where the courts are on deference on this?
Hi, thank you for this. This has been great. A follow-up to that question the person before me had. Do you see, though, that the way that our government so far in the past year has framed national security threats, including domestic ones, where the White House has both directly and indirectly implicated millions of Americans as being national security threats themselves, possibly could skew both the courts and just like the court of public opinion? Like, do you have any thoughts on like how that might impact feelings about AI and regulation and visibility in the national security sphere, but also just beyond that too?
Want to take that one?
Well, I'm just the moderator.
I think it's certainly the case, as your question suggests, that there are a lot of cases going on right now that are being put in the national security bucket that we might not have seen. They're relatively new issues. So the Alien Enemies Act, for example, being invigorated, that is a statute that the courts have not had to wrestle with for a long time. And some of the lower courts have not been as deferential to the executive as we might have expected in the past. So I think I'm going to say watch this space, right? These cases are, many of them are going to end up at the Supreme Court or are currently at the Supreme Court, and that those cases are going to tell us how the Supreme Court is thinking about the levels of deference that are warranted. And those decisions are going to have, I think, important wider implications for the sort of generic national security cases writ large, maybe including cases that are invoking the executive's use of AI in the military space. I'm skeptical the closer you get to the kind of traditional military battlefield decisions, and the further you're getting away from domestic activities, the more likely I think you are to see deference endure.
So let me ask you just one final question, which is, obviously you've had an illustrious career in the national security space. What advice would you give to law students who want to practice in national security, or more specifically in the intersection of national security and AI?
So I think I would go back to the point I made to the online question, which is that first they should take classes with you. They should take national security law classes. I think they're increasingly in law school are classes about AI in the law. Those are going to be very valuable. But in general, trying to get smart on the tech. And by that, I don't necessarily mean you need to know how to develop an AI system on your own, but you do need to understand the different types of systems. You need to understand how systems can be used in ways for which they were not developed and what the possible implications are for that. You need to understand how the data that's being, that the systems are being trained on, what are the sources of that data, how do you know whether it's been collected lawfully, things like that. That's the way I think that we as lawyers can help engage in this debate and can help make sure that we are asking the right questions as actors in the government are thinking about whether to develop and deploy systems that they are notionally thinking about.
Well, Professor Deeks, thank you very much for this fascinating presentation, for the book, and for the conversation today.
Thank you so much. Really appreciate it.
Thank you. Thank you all so much for joining us, and we hope to see you at a future event. And if you have any feedback on the event assistant, please share it at brk.mn/feedback. And give it up for Professor Eichenseer and Professor Deeks. Thank you so much for joining us. Really appreciate it. Have a great day, everyone.